Good evening, everyone. I can see that our mentor is on the call with us, Mr. Emmanuel Iwere. Good evening, sir. Good evening to all our mentees on the call. I hope we are all having a good day so far. Good evening. Good evening. Our mentees, are we on the call? Someone should reply me, please, and let me know if you can hear me loud and clear. All right, Obona, thank you very much. Thank you very much. As we all know, we have a very, very broad topic for today. Today is the week 3 of JIIPCC Mentorship and Internship Program on data protection and privacy. And our topic for today is data subject rights, which entails overview of data subject rights, the rights to access, rectify, and delete personal data, the rights to object and restrict data possession. That's the topic we'll be taking for today, and we have both prestigious mentors. I believe we are all acquainted with them by now, Mr. Emmanuel Iwere and Mr. Solomon Okedara. I can't see Mr. Solomon Okedara on the call yet, but we assume he's joining us very soon. So I'll be giving the floor. So we are just jumping into the main topic for today. There's no announcements. I believe we are all acquainted with all that by now. So let's just jump into the topic for today because of time. Mr. Emmanuel, you'll be giving us an extensive overview of the topic on data subject rights. Thank you very much, sir. The floor is yours.
Thank you very much, everyone, and thank you very much, Mr. Hussein. It's great to be here today, and I'll put on my video. Just hold on. All right. Good afternoon and good evening to everyone, and we will be discussing a very interesting one today. That is the rights of a data subject, and before I proceed on this, I'd like
Sorry, Mr. Emmanuel, you are muted. I think I mistakenly, because some mentees are muted, so I was trying to mute them and I mistakenly mute you also. Sorry.
Okay, can you hear me now? Can you hear me now? Hello?
Yes, sir. Yes, sir, we can hear you now.
Okay. All right, thank you very much. So I'd like to ask a question to the House. Based on our previous discussion on a data subject, so can a dead person be referred to as a data subject? Who can give us a quick answer?
I would say yes. I'm just guessing.
I think that a dead person also has data, and the data is also categorized as personal. So yes, a dead person can still be a data subject.
Do we have any contrary answer? Okay, I will take it up from here. Now, this is to make you understand that that a data subject, based on the principle of privacy and data protection, can a data subject can only be somebody that is alive. So a dead person cannot be referred to as a data subject, but this varies with jurisdictions. So please just take note that as for now, we're referring to only those alive and those that are identifiable and those that can easily be traced. So the whole essence of the data data protection ideology is centered on something. It's centered on the protection of a person referred to as the data subject. So whenever you hear about data protection, you rest assured that the concept is built around a particular person, the data subject, and it is geared towards ensuring that the data subject is well protected and they enjoy their rights. So this gives us the idea and the path to our today's topic. What are those rights that a data subject?
Recording in progress.
Are we together? All right. What are those rights that a data subject is entitled to? Now, first of all, I would like to point out the very first right, even though we tend to neglect it, we tend to put it aside. Even I noticed it is not part of our list here, because from the first one we have here is right to access. But the very first one is the right to be informed. And when it comes to informing the data subject, it goes down to consent. Apart from consent, now we look at, when we talk about right to be informed, we have the what data you're processing, who is processing my data, which information do you require, which information are you processing, how long are you keeping my data, what particular data are you processing. A data subject is entitled to be informed on all these very facts, even in a case whereby his data will be transferred to probably a third-party international transfer. Whatever the transfer will be like, a data subject is supposed to be aware of whoever is processing his or her data. Now, this brings us to the next one, the right to access. When we talk about access, we're talking about availability, and which is part of the fundamental. The data subject must have the right to access that information that he has given to any controller or processor. Now, let me give you an instance. Just imagine you sharing your data to a controller, and he told you this is what we're going to do with it. This is the quantity of data that we require, and this is how we're processing it. And at the end of the day, after processing your data, you're requesting, okay, can I have a copy of what you have done? Can I see what you have, can I see the particular data you have processed? And the data the controller is trying to, like, okay, I already have your data. There's no need telling you or informing you or sharing any particular information with you. Now, when it comes to the principle of data protection, it is compulsory, it is mandatory that a controller or a processor must allow the data subject access his data at any given time, and he must have knowledge of what will be processed or have been processed. Then this leads us to the next right, which is the right to rectify. When it comes to rectification, now, for a data subject to have his data updated, he must be able to know that particular data that is being processed and confirm if it is up to date, and where it is not up to date, he is obliged to rectify. When it comes to rectification, he can correct. Let's give an example. If you have given a controller your particular address as of last year, and this year you change location, it is required of you as a data subject to rectify that particular data with the controller, letting him know that I have changed my location. This is my current location. Can you rectify whatsoever you have available with you? So this leads us to the next right of the right to erase. Some persons will call it the right to be forgotten. Now, this right is actually the ability to tell a data controller or a processor that, can you erase my data? Probably he's processing and you're not comfortable with that particular data he is processing, you have the right to request that that data should be erased. But now this is something very important that I must bring to your notice, that this right to erase is not an absolute right. So there may be circumstances in which a data controller can retain that personal data despite the data subject request for it to be deleted or to be for it to be deleted. So be rest assured that this right is not absolute. A data controller can also retain, let me give you an instance where there's a particular law that permits a controller to retain data in the EU. It could be for 7 years. So where you're requesting for it to be erased, a data controller can hold that data until the expiration of that given time. So just know that this right to erase, it is not absolute. Then this leads us to the right to, are we together? Before I proceed, are we together?
Yes, sir.
Hello?
Yes, sir. We are together, sir.
Yes,
Okay, perfect. So now I've been talking about this very right, and I will make reference to our Data Protection Act, which is available to us right now. These rights are mostly explained in section 34, subsection 1A and downward. So you get to have a full knowledge about this. Then I will go further to other rights as well. We have the right to stop the processing of a particular data, or even whatsoever a controller is processing. So this right is also not absolute, remember, and a data subject can ask a data controller to stop the processing of his data at any given time, even in the middle of the procession, where a data subject feels that he is not okay with the processing of that particular data, he can withdraw his consent. So this also relates with consent. So consent can be withdrawn at any given time. I don't know, is there any question in regards to what we have been discussing so far? Hello, house? Hello, any question? Any question?
Mentees, if there's any question, can you raise your hand? And
hello, yeah,
ask
with
the
you, sir.
question.
Sir, hello, sir. I would like to ask, you said consent can be withdrawn at any given time, but what if the data has already been processed on the instruction or the initial consent given by the data subject, sir?
Very well. Now, I love this question. We talked about the right to erase, isn't it? Now, where the data has been processed, you can request that that particular data should be erased. So now, where the data is being processed, you can stop the procession. Stop processing my data. Where it has already been processed, you can tell the controller, erase what you have processed. I don't know if it is clear.
Yes, very well, sir. Thank you, sir.
All right, all right.
Yes,
Then there's also another, any other question before I proceed? Thank you very much for that very lovely question. What's your name?
Oyinkansola, sir.
Thank you very much, Oyinkansola. I have taken note of you, and that question came in fact, came the right time. Nice question. Thank you.
Yes, sir.
All right, let me proceed. And let me explain the last concept of right to data portability. When it comes to the right to data portability, I'll give an instance. I believe that most of us who have had the opportunity to maybe fall sick, visit the hospital, we go to see the doctor, we tell him this is what is wrong with me, this is the challenge I'm having. You furnish him with your health data, and at the end of the day, they will now process your data, treat you, do some tests, and at the end of the day, they will now bring the result result to the doctor. And you will now be there waiting for your results. All of a sudden, the doctor will write some kind of signatures and give to you that is your report. You guys are very familiar with that, right? Now, such information that the doctor has given to you is something that you cannot comprehend. Not even in fact, it's just his fellow doctors or his medical persons that can interpret it. Now, when it comes to the concept of data portability, it must be in a machine readable form. So apart from the fact that a controller, a processor, now let me come back, that doctor it's actually your right to collect your data in a form that you can read and understand it. So it must be in a form in which it can be understood, and it must be machine readable format. So you can connect it with any form of machine, and it will be able to interpret it that this is the information contained therein. So this is where I would like to stop for now, and maybe I'll talk about the rights in relation to automated decision making and profiling later, because this is more with it's actually a right that is in the EU they take very, very serious. No machine can autonomously take any decision without any human intervention. So that's what the right is all about, that no machines should decide. Let's give an example again, where there's a mass application for job, and because of the volume of the application, some organization would choose to use AI to screen the applications, and after then they can now start deciding, okay, the software may also decide who are those that will get the job. Now, this is where the right to non-automated decision-making without human intervention comes in. Such AI should not make decisions solely without any human input. There must be human input after the company has allowed the AI to screen the whole CV. Now, there must be human input to also decide as well. This is the clearest explanation I can give to this regard. So thank you very much for this time. I would like to hear from you on your presentation, and also I will make my comments later on. Thank you very much, Mr. Hussein.
Thank you very much, Mr. Emmanuel Ewere, for that brief introduction and overview. And as brief as it is, it's very, very informative and rich. So we can't find Mr. Mr. Solomon on the call yet. So we'll await him whenever he joins the call for his input. But for now, let's quickly take the picture time before we jump into our mentee's presentation for today. So I encourage everyone to put on your videos, smile for the camera as we take our screenshots. Thank you very much as you do so. Thank you, thank you, thank you. So Bunda, we can't see your face. Thank you very much. Yeah, let's smile. Okay. All right, thank you very much. So I'll be taking the presentations now from our presenters. Let's give the floor to presenter one, presenter for group one. I hope you are ready. I hope your slides are ready. Kindly share your screen and start your presentation. Do we have our presenter on the call? Presenter for group 1. I think I saw her on the call just now. Obunda, you are the presenter for group 1, and you are muted. You are not talking. We can't hear your voice. You say? Okay, group 2. Okay, Cynthia is the presenter for group 1. Do you have Cynthia on the call? Cynthia or the backup presenter for group 1? Who is the backup presenter for group 1? Ezine. Yeah. I can see Ezine on the call. Ezine, you are the backup presenter. I hope you prepared. Ezine, Iwu, are you on the call? I can see you on the call. Okay, let's give Ezine a few more minutes to prepare as I'm calling on her just now. So group 2's presenter can start now. While group 1, please, if the group leader is also on the call, kindly reach out to your group members and inform them that we need a presenter ASAP.
I don't know what's happening with my camera. My video has been turned on. So I don't know what
maybe it's
happened.
the application. Maybe you delete and so just share your screen, yeah.
Okay. So let me share my screen. Oh my God. Can you see my screen yet? Hello?
We can't see your screen yet.
I don't know what's happening with my Zoom.
Can someone from group 2 share your screen on your behalf? The backup presenter. Tolu Nife. Lillian is also on the call. Lillian is in group 2. Kindly help the presenter to share the screen.
Hello,
Sinanya is also on the call. Okay, Lillian is sharing the screen for you. Thank you very much, Lillian.
Right. Okay, thank you. So from group 2, our topic was on the rise of the data subject. Can everybody hear me?
We can hear you loud and clear.
All right. So our topic was on the rise of the data subject. The first one was the right to access. So basically, what the right to access meant, what it implied was that the data subject has the right to request from the data controller the data they have on the subject. So that basically means the data subject can ask, okay, let me see the information you have on me so far. The right to access actually opens up other rights, like right to rectification, which will be the next on our list. The right to access is stated in section 34 sub 1B of the Nigerian Data Protection Act. Hello?
Hello? Can hear you.
All right. In section 34 sub 1B of the of the Nigerian Data Protection Act. Next right is the right to rectification. The right to rectification flows directly from the right to access. It's basically saying that the data subject at any point in time can decide to update the information held or the data held by the data controller. For example, I remember a while back, I opened an account with a bank, and then I realized later on that they spelled my name on the account. And I had to go to the bank and tell them, this data you have about me is incorrect. And they gave me a whole procedure and everything on how to rectify that data. That's an example of data rectification. It contains in section 34 of 2C of the Nigerian Data Protection Act. And as far as the data subject data is held by the data controller, if there's any inaccuracy, if there's any changes, if the data is misleading or incorrect, the data subject has the right to ask the data controller to please update and correct that information. The next right is the right to delete personal information. This is also known as right to erasure, some call it the right to be forgotten. So it basically means that the data subject has the right to, at any point in time, decide that they don't want the data controller in charge of controlling their data or processing their data anymore, and can ask that their data be permanently removed from the database of the data controller. But one thing you know about this right to be forgotten or right to erasure is that at the point in time where the request is made to that the data be forgotten, all data held on that data subject is what is removed. It does not stop the data subject from in future deciding, okay, this data controller can at this point in time now continue with processing my data or can be in charge of processing my data. The next one is the right to object. The right to object is basically saying that the data subject objects to the processing of their personal data. This right is not, it means that in certain situations, even if the data subject objects to the processing of their data by the data controller, the data controller will still be able to process their data if it is in line with maybe public interest, by law, and some other situations. But it's basically allowing the data subject, to say that if there are grounds of legitimate interest, I don't want this controller in charge of my data anymore. It's provided for by Section 36 of the Nigerian Data Protection Act. And the next one is the right to restrict data possession. The right to restrict data possession is basically saying that a data subject can give out their data to a data controller and restrict the usage for which the data controller processing their data for. So you can decide to release your information to a bank and tell the bank, this is strictly for purposes of banking. I don't want any advertisements. I don't want it to be used for digital marketing. So every data subject has that right to restrict the use of their data, provided for in Section 34 of the Nigerian Data Protection Act. And Article 18 of the GDPR also provides data, also in conclusion, all these rights are to protect the data subject and to allow the data subject to be in control of the processing and the use of their data. It all boils down to consent, which is very vital in data processing and privacy. Thank you.
Thank you very much, able presenter for Group 2. Ubunda for that wonderful brief presentation. Is our backup presenter or presenter for Group 1 ready now? Ezine, you will say she's ready. So you can start your presentation now. Thank you very much. I would also acknowledge the presence of our profound mentor, Mr. Solomon Okidara. Good evening, sir, and welcome to the call.
Good evening, everyone. It's my pleasure to be here once again.
All right, thank you. Group 1's presentation, so we can go now.
Good evening. Can you see my screen?
Yes, we can.
Yes,
Okay.
we can see your screen now.
Okay. Good evening. My name is Ibu Ezine. I'm the backup presenter for Group 1. And our topic is data subject rights, overview of data subject rights. So a data subject simply means a person, a data subject simply means an individual who can be identified directly or indirectly. It simply means a person who can be identified by certain personal data. And the rights of the data subjects are simply those rights that are recognized and granted to data subjects with respect to their personal data under the applicable data protection laws. In Nigeria, the privacy and data protection rights of the data subjects are the rights to privacy and data protection of the data subjects are rightly stated in the Constitution and the Nigerian Data Protection Act, particularly in Section 37 of the Constitution, which simply provides for the right to privacy. And then for the rights under the Nigerian Data Protection Act, they act acts like a legal framework for the protection of personal data of data subjects in Nigeria. And the data subject rights include: 1, the right to be informed. This is provided under Section 37, sub 1, paragraph A of the Nigerian Data Protection Act. And it simply means that it simply allows individuals, as the data subjects, to know what their personal data is collected for, how it is processed, how it is stored, and as well lodge a complaint to the authorities when they have any issue with it. The second one is right to, sorry. Sorry, the second one is right to access, and this is provided in Section 37, sub 1, paragraph B of the Nigerian Data Protection Act. And this right simply allows individuals to Can you hear me?
Hello, me. Madam, give me. Can
you hear me? Oh, jeez.
We can hear you.
Okay. I thought I was having a network glitch. The next one is right to access. This is provided under Section 34, sub 1, paragraph B of the Nigerian Data Protection Act. And this right simply allows individuals to access their personal data from the data controllers. The next one is the right to rectification. It is provided under Section 34, Sub 1, Paragraph C of the Nigerian Data Protection Act, and it allows the individuals to ask the data controllers for an update on their personal data, and as well as correct inaccurate data. And then the next one is right to be forgotten, which is provided under Section 34, Sub 1, Paragraph D of the Nigerian Data Protection Act. This right simply allows individuals to request their personal data to be deleted by the data controllers, and it originated in the Google Spain case. The next one is right to restrict processing. It is provided under Section 34, Sub 1, Paragraph E of the Nigerian Data Protection Act, and it allows the data subject to request that the data controllers limit the way it processes the personal data of the data subject. And then the next one is right to data portability. It is provided under Section 34 of the Nigerian Data Protection Act, and it allows the individuals to obtain their personal data from the data controller, as well as request that their personal data be transferred to another organization or another data controller. And then the right to object to processing. This right is provided under Section 36 of the Nigerian Data Protection Act, and it allows individuals to object to processing of their personal data at any time and in certain situations. And then rights in relation to automated decision-making and profiling. This right is provided under Section 37 of the Nigerian Data Protection Act, and it simply provides that the data subjects have the right not to be subject to automated decision-making by the data controller. But then if the processing is subject to any one of the legal basis for processing data, the data subjects will not be able to exercise this right. And then in conclusion, the data subjects rights provided under the Nigerian Data Protection Act is a step forward to ensuring that the data subject is placed in a central position and has the power over his personal data. Thank you.
Thank you very much, Ezine Iwu, for that presentation on behalf of your team and your group. Thank you very much to the both presenters for today. We've taken the overview of the topic from Mr. Emmanuel Ewewe, but we also want to take the overview of the topic from Mr. Solomon Okedara. And we've also taken this picture time already. So Mr. Solomon, you've missed out a lot. So kindly put on your video so that you join us to take another picture. We can never get tired of taking pictures. So just turn on your videos if you can, so that we just smile for the camera. We have Mr. Solomon on the screen with us. Thank you very much.
The pleasure is mine.
Okay. So while we are taking the pictures, our topic for today, data subject rights, an overview of data subject rights, the right to access, rectify, delete, and object and restrict personal data. So that's the topic that you'll be taking us on. Thank you very much, sir. The floor is yours.
Okay, so once again, good evening to everyone. Can you hear me?
Yes, sir, we can hear you.
Okay, so Yes, it's a very important subject, and one of the things I realize is that when we are talking about data protection, we oftentimes look at two important actors, and of course, they are first the data controller, and secondly, the data subject. And of course, in reality, before we can say, look, I'm the data subject here. Now, and I have some things I need to assert. Then we're talking about rights. And so for me, that actually implies that those rights are very, very important, and they form the basics of enforcement, or assertion, as it may be. So far, so good. Of course, I've listened to the two groups making their presentation. Be that as it may, I think I may still have to come back to the presentation. But of course, generally, at the risk of repetition, because I know that Mr. Emmanuel will have done justice. But then, of course, we know that data subject rights comprises the fundamentals, which includes the right to be informed. And of course, we have the right to access. We have the right to be forgotten, the right to further restriction of further processing, right to data portability, right to object, right to complaints. I am not sure of if any group actually made mention of right to complaint. But more importantly, I think I would just take liberty of not listening to Mr. Emmanuel's presentation to just hint on a couple of things, which if he has actually hinted on them, we just have to pardon me. So let's look at the right to access. So when talking about right to access, one of the fundamental things is that, when you're talking about right to access, you oftentimes come across the acronym DSAR, which is Data Subject Access Rights. So, and when you are doing that, the first thing is when a data subject makes a request to a data controller or is or a data controller, the very first thing the data controller needs to do is to verify identity. So I'm going to give us an example. Now, let's say Ezine decides to proceed to Harvard Law School for master's, LLM. Now, when Ezine reaches out to the academics or the results office of our school, the first thing the results office needs to do is to verify the claims and identity of Ezine as the applicant. So when that is done, then the authority or the department will need to get back to Ezine that, okay, yes, we have received your application, we have confirmed you are the person. If for whatever reason they have not confirmed or they could not confirm, then they will make a request, a demand for some information. Is Ezine still in the room? Ezine?
Yes.
Okay, please. So, what level are you, please?
500.
Great. So, I'm sure someday you will love to take your LLM in Harvard or Columbia or Yale or Princeton or Cornell. Is that correct?
Yes, sir.
So, what is wrong with Lagos State University? It's okay, it's fine. So now you need to, you're trying to get your transcript to Harvard Law School. So, and you have applied to your university, or you have sent an email, or you have reached out on phone. So what kind of information do you think your university will request for to verify your identity?
The rights to access.
No, you did not hear my question. No, I'm not sure you heard that question.
Okay.
I said in trying to exercise your right to access. Now you have in exercising the right, you have made an application to the university. Now, and you say, look, I need to, in fact, in that particular example I'm citing, I actually brought in two particular rights. So, and I'll actually bring them out. The first thing is that, please, I need to access my my transcripts because I'm making an application for LLM to Harvard Law School. So, and you've sent in the application, then the university authority needs to verify your identity. What kind of information do you think they will request for?
Sorry, I don't think I got the question. Are you asking for the rights or the information that they're going to request for?
Okay, so let's do this. As it focus on the narrative, on the story. You and I have agreed that you are taking LLM in Harvard. Is that correct?
Yes, sir.
So you have sent in an email or you have placed a call to the registrar and you say, please, my name is Ezine and I want to get my transcript. I'm applying for LLM in Harvard Law School. So, and the gentleman at the other hand, of course, is Robert. And Robert is saying, good afternoon, Ms. Ezine. I need to verify your identity. So what kind of information do you think Mr. Robert will request for from you? Somebody is answering some of the question already, but I'm not sure that I'm not going to respond to that. So I leave that to Ezine. Or Ezine, are you using, do you call a friend without me asking you the question you call a friend?
No,
I'm not
sir.
giving you that option. Maybe a friend willingly chose to help out. Well, okay, so can I have your response, Ezine?
The person will be asking for my details, my name, and my name and other documents from school.
Isn't it you are following my hand? Why now? Eh? Are you sure we should consider you for the LLM in Harvard Law School? Are you sure? Okay, it's Olabi Yimiriam on the call. Olabi Yimiriam. Where is she? Okay, so let me reach out to, is Lillian on the call? Chika, are you on the call? Oyinkansola?
Yes, I'm here, sir.
Who is there, sir? Who?
I'm here, sir. Oyinkansola.
Okay, Oyin, how are you?
I'm very well, sir.
Someone said you're applying for LLM at Columbia Law School. Is that correct?
Very well, sir.
Great. So you have called Mr. Adegoke. And Mr. Adegoke is saying, good afternoon, Mr. Oyinkansola. Please, I need to verify your identity. So what kind of information do you think you will proceed to ask for?
Well, academic records, probably my full name, matric number, address, year of graduation. I think you will need all those. Then my department. Excellent,
excellent. Thank you so much. I don't know whether Ezine just had a nap and she woke up in the middle of convocation or graduation at Harvard Law School after, sometimes when you so much, I've painted the picture in your head, you travel to the end, even when you have not begun. Ezine?
Yes, sir.
This is the information I expected you to give me. Eh?
Okay, sir.
Okay, but it's fine. So basically, your university as the data controller will need to, or has a duty to first verify your identity. So isn't I'm coming back to you. So if your university chooses not to verify your identity and they proceed to process a transcript, and you eventually find out that the transcript sent to Harvard Law School or the clearinghouse for admission in US, I think it's called CAS or so, I've forgotten now. Now, and the Harvard is saying, look, Ezine, we are yet to receive your transcript, But this could confirm to you they sent the transcript. Actually, they sent the transcript. But what happened was that they sent transcript belonging to another person. So why do you think such error was committed?
Maybe because they didn't verify my identity.
Excellent. They did not verify your identity because you see, now the first thing is that they need to verify your identity and be sure that the information they are responding to actually is consistent with the identity of the data subject who has made the request. And that's why, verification of identity of the data subject making the request is very important. It is not just enough to say, okay, oh, SNA has made a request, and we proceed to process, transcript belonging to SNA or CAFO, which is very possible. So they need that verification is not just, oh, give us your matric. For example, just like Sola said, if you are provided matric number, they will look at the matric number you're provided and the matric number on the results they are about to process. They realize that they match. So when they realize that they match, then that takes them to the next stage, which is response. So in that situation, they now respond to you that, okay, Madam Ezine, we have gotten your result. Then of course you need to make payment for this and this and this and that. So then when they do all of that, then the next thing they do is to accede to your request, which is to send it to Harvard Law School. In that story, that narrative, how many rights of yours as a data subject was exercised or were exercised? How many? Was or were? So let's put it that way.
Right to data portability, right to access, right to be informed.
Okay. Oyinkansola, isn't it? Before I go ahead, are you sure of all of those three rights present?
Yes.
Final answer. Or you want to call a friend?
I'm sure.
Now, the story is let me play it out. I'm much actually concerned about the practical analysis of our learnings than the presentation. The presentations are fantastic. But I'm saying, you see, unless we internalize it, it will just be for head knowledge sake. So you made a request to your university that please, I need this transcript to be forwarded to Harvard Law School. And they actually acceded to your request, of course, with all of the details we went through. So you are saying they have actually, you exercise your right of access, your right to be informed, and your right to data portability. Is that correct? Is that what you said?
Yes, sir.
Okay, thank you. Oyinkansola, are you still in the room?
Yes, sir, I'm still here, sir.
So how many rights of yours were acceded to?
Well, I'll say right to access and the right to data portability.
Just two?
Yes, sir.
Okay. Who else is in the room? Blessing, Chineye, Ian, Chika, Miriam. Is any one of them in the room? If you are, please just indicate.
Yes, sir.
Yes, sir.
Who's?
Yes, sir.
That's Blessing.
Yes, sir. Yes, sir.
Yes,
Okay,
sir.
please just mention your name as you say yes, sir.
Okay, Chika is in the room, sir.
Okay, Chika. So, please, how many rights were exercised in that story?
So please, can you go through the scenario once more?
So Chika, you have applied for LLM at Aba Law School. I think that's actually a great one, right?
Yes, sir.
Excellent. So then you have applied to your school to send your transcript to Aba Law School, and of course, in that situation, your university is saying, okay, please verify your identity. You have done that, and of course, they now told you that look, for us to process your transcript to Aba Law School, you need to pay this, you need to pay this, it will take this time, and they give you, they are supplying you some information, and of course, you made the necessary or requisite payment, and they forwarded the transcript to Aba Law School. In that scenario, how many of your rights did you exercise?
So I'll say to my rights to my right to data portability, and then my right to be informed.
Okay. Who else is in the room other than
I think they are.
Yeah. Ooh.
Sir,
Is Blessing in the room?
yes, sir. Samia.
Okay, so Blessing, did you listen to the story?
Yes, I did.
Okay, so how many of your rights? I mentioned them.
Okay. So right to be informed and right to access.
Okay, right to be informed and right to access. Blessing.
Yes, sir. Yes, sir.
Are you sure you are not on vacation?
So I'm sure I was not.
Are you sure you are not in Miami somewhere chilling while all of us were doing the presentation? Maybe you are sipping an expensive wine, relaxing, looking at nature.
No, sir. No, sir.
God was
No,
watching and is watching you. All liars must repent. Mm-hmm. So who else is in the room? Yes, Ogunda. Okay, so let me have your understanding of what happened in that story. How many of your rights were exercised?
I think it was the right to access, right to be informed, and then the right to data, right to restrict, because it was specified to forward to a certain university.
Say that again, Ogunda.
It was right to be informed, right to access, and also right to restricted. They restricted the data to a particular university. The data should be processed for the purposes. Since you are forwarding for the purposes of this.
Okay. So guys, so that we are able to get it correctly. For those of you who said you exercise your right to access, please can you tell us again how you were able to exercise your right to access? What happened was that you made a call and you made a request that your transcript be sent to Aba Law School. Now, if we have a narrative that says, okay, you know what? I need my transcript to be sent to me and be sent to Aba Law School. Would that have made a difference, Chika?
Yes, it will restrict some of the. It will not affect all the rights that we mentioned right now. It will be your right to access your data and right to data possibility.
Mm-hmm. Okay, so Chika,
in this particular situation, why I mentioned the right to access is because it has to be you as a person that says, okay, I need access to so and so information to be forwarded to so and so person. That's why I said the right to access.
Okay.
So you have to have access to it to be able to give it or forward it to the university. So if it is not that person in particular, then the person, if it was a third party, for example, then the third party would have to obtain the consent of the data subject.
Oh, okay. So Chika, to your understanding, you are saying whether you request that the school sent it to you or not, right to access was exercised.
Yes, because the school has to confirm that it's you that is asking for it.
Okay, guys. So I think most of us will not agree. I argue with the fact that right to data portability was exercised. I think all of us agree to that. Is that correct? Or
Yes,
most
sir.
of us. So I think someone did not agree. Who is that person? Raise up your hand now. Raise up your hand now. Aha, the person has left the room. Okay, so all of us, I think most of us agreed that right to data portability was exercised. Most of us agreed that right to be informed was exercised, particularly when the university was actually telling you the conditions of processing it and the timeline it will take them for it to be received in Harvard Law School and all of that. I think we all agree to that. Is that correct?
Yes, sir.
Okay, so let me talk to Mr. Emmanuel if he's still on the call. Mr. Emmanuel. Mr. Emmanuel. Is he still on the call? Hey, I guess he's busy.
Mr. Emmanuel is still on the call.
Okay. Maybe it's, I don't know. I'm trying to, I wish you're still on the call. I think I just want all of us to be clear as to our understanding of right to access. Okay, so while we are waiting for him, isn't it?
Yes, sir.
So let me ask you again, will it have been different if, in the first story, you didn't ask the school to send a copy of the transcript to you? All you made your request was to send it to Harvard. If you have asked them to send a copy to you, will the rights have been different? Will it still have been the same right?
I think so.
I don't know what you're thinking.
Yes.
I'm not in your mind. What are you thinking?
Yes.
What are you saying yes to? Isn't it?
That will still be the same thing.
Elisa,
Okay. Yes.
are you by any way saying the right of access is only limited to when the data subject is requesting for that data to be sent to him or her personally?
No, I'm not making a position at the moment.
Okay,
so
sir.
I need all of us to have have a broad understanding of what right to access is all about. That's what I'm saying.
Okay, sir.
That's why I have to. Will it be different if you are saying, okay, please, school, send me a copy of my transcript and send a copy to Harvard Law School? Will it be different? Or will it? Okay, so the narrative is that when I am saying send a copy to Harvard Law School, we have said right to data portability, right to information, and right to access. Some of you said that. And I'm asking if you are saying, please send a copy to Harvard Law School and send a copy to me. So what are we saying? Or does somebody want to change his or her position to say, no, the first one does not include right to access. It's all about right to data portability by reason of which they had to exercise, they had to acknowledge my right to information. But if I've made the request that the copy be sent to me, then of course, then right to access. So let me know what you're thinking. Or somebody said for them to be able to accede to my request, it's an exercise of my right to access. But I'm saying, but so that's what I want us to look at liberally. So I'm reading what Lillian said. Lillian said, if I requested for the transcript be sent to me, then the right of access comes in. The right to access applies to both scenarios. That's what Ezine said. I have my view. I have what I think. It's my position. I mean, I may even be wrong. Some of you may be right, but I think I have because we need to go to the root of what we consider to be access. What is access? Now, for the fact that I request that the school send the transcript to Harvard Law School, does it mean I have accessed my results or my personal data? Does it mean I've accessed it? Isn't it?
Yes, sir.
So what is access then? Can somebody tell us what access means? What does it entail?
It means that you have a pathway to gain certain information.
It means that what?
You have a pathway to get certain information.
Okay. So what was your own response? Was your response that the first story includes right to access?
Yes.
So in that story, did you get the information, or another data controller got the information?
You got the information you needed, because what you needed was that it be sent to the university. So you got the information you needed.
No, let us mix it up. So let's actually use proper terms. The information that to be sent, and your please, let's restrict ourselves to the whole context. We are talking about access. What are we accessing here? Your personal data, not just the information of whether it was sent to another data controller or not. That's not what we are talking about. What you are trying to access is your personal data. So that document contains your personal data. So the question is that you access your personal data by sending the document containing your personal data to Harvard Law School. Maybe that will help us to understand how and which rights were exercised. So Lillian said, access means that the subject can gain the information from the controller for his or her personal use. The information, I have a problem with the use of the word information. That's not correct. Now, you see, because what the focus of that right is to access your personal data, not the information. You can have an information that, for example, so let's change this. Let's tweak it a little bit. So Lillian or Ezine, what you did was I just made a call. Oh, Mr. Robert, please send my CV, my transcript to Harvard Law School. And your transcript was sent to Harvard Law School. In that situation, you exercise your right to data portability that the university kept as a data controller to you. Did you also exercise your right to access your personal data in that situation?
No.
We just answered Chika, right? So Ezine said no. And who else agreed that in that situation you did not exercise your right to access? Hello?
So,
did we hold take something heavy this afternoon? I think the room seems dull to me. But guys, so you see, at the very base of our conversation on this program, like I always say, let us prioritize real competence acquisition, not just head knowledge. Yes, anybody can put together slides. Anybody can put together a presentation and read it out and say, oh, fantastic. No, excellent. But see, when you are confronted with real life situation, you won't be looking for your transcripts, your slides anymore. At that situation, even to give preliminary advice or tentative opinion, you need to be able to sit down and look at the situations. What right was exercised? What right was not exercised? It's not all situations that you need to be looking for your notes, your journal, your slides, and all of that. And that's why I asked the question. And please, let us learn to understand context. In data protection class, let us limit ourselves to the use of the word data and not information. The word information does not necessarily mean data. Yes. Please. So, and the word data does not necessarily mean personal data. So my question again, if we have sent a mail, if we have completed a form requesting that your transcript be sent from your university where you bag your LLB to Harvard Law School, and of course they comply, they gave you conditions and all of that, and at the end of the day, they forwarded the particular requested information or that document containing your personal data to Harvard Law School. Have you been able to exercise your right to access? Nobody's talking.
I don't think so, sir.
Who said she doesn't think so?
Uyikosola, sir.
Uyikosola. Okay, so on a final note, if you think, if you're sure, if you're convinced that you still exercise your right to access in that situation, that narrative, please say, hey. Don't worry, say, hey. Nobody will flog you. I can assure you, I can guarantee. Okay, so you see, why is it that we are not confident to stand by our position? You know, somebody said, don't be afraid of standing alone. As you are, as long as you're standing for something you believe in. Okay, so it's all right. So if you believe that only your right to data portability and your right to be informed were exercised, can I hear you say yes? Nobody's talking. Okay, so I'm going to be taking down some things now. If I do not hear your voice for any of the answers, then I agree that you did not participate into this class. So if you agree that only right to data portability and right to be informed were exercised in the narrative, let me hear yes. Mention your name and say yes.
Oyikosola, yes, sir.
Oyikosola, yes. Okay. Yes, that means only right to data portability and right to be informed were exercised by you. Is that correct?
Very well, sir.
Lillian,
okay.
yes, sir.
Lillian, yes. Okay.
Chika, yes, sir.
Chinaza, yes, sir.
Chika. So I have Oyikosola, Lillian, Chika. Who else?
Chinaza, yes, sir.
Miriam, yes, sir.
Miriam.
Yes, sir.
Okay. Awu.
Blessing Bill, yes, sir.
Blessing Bill, yes. Who?
Yes.
Chinaza, yes, sir.
Chinaza, yes. Who else?
Ezinne, yes, sir.
Okay, is that all? If you're standing for no, can I have your name?
No. No.
Chika, actually. Chika is no. Chika is no. Who else? So we have only 1, 2, 3, 4, 5, 6, 7, 8 persons in attendance in class this evening. Is that correct? 9. Moderator. Is our moderator still in class?
Yes, sir.
Okay, sir, please. The names I have recorded to have participated in today's class are these. Please take note of them, please. Oyekosola, Lillian, Chika, Miriam, Blessing, Chinaza, Ezine, Chika.
I didn't get all of them, please. Yeah.
Oyekosola.
Yes.
Lillian.
Yes.
Oyekosola, Lillian. Chika.
Yes.
Miriam.
Yes.
Blessing. Chinaza.
Ezine. Okay.
Ezine. Chika. 1, 2, 3, 4, 5, 6, 7. 1, 2, 3, 4, 5, 6, 7, 8. 8. I don't know, there could have been 50% who signed on.
Chika. You have Chika twice. I don't know.
Oh yes. I have Chika twice though.
There are 2.
Yeah, we are 2.
Yes.
Okay.
Yes.
Chika 1 and Chika 2.
Osuji Chika is the one that said no. And the other.
No, I'm the one that said yes. Also, Chika is the one that said yes. To yes, right to be informed and right to data portability.
Okay. Then the other Chika. Please, what's your second name?
Obunda.
Okay, so you said no, right?
Yes.
Okay, so we have 8 persons in class. Is that correct, moderator?
Yes. Yes, sir.
Oh, 8 persons actually signed up for class this evening.
Not 8, sir.
How many?
Some of them have left.
They have left.
Okay. 15.
No, it doesn't matter. By my records, we have only 8 persons who attended this class. Okay, so guys, well, whoever. So what you're going to do for me? I'm going to give you an assignment, and just do. You can do a 1 paragraph or 2 paragraphs answer to it. Now, and please submit it by Thursday next week. So whoever gets it, whoever gets the highest score, so there are going to be 2 categories. The first category is for everyone who gets it, you will get a prize. And before you start thinking it's for some important prize, let me bust your bubble now. Okay? You get a bottle of Pepsi. And anybody who gets it right, the number 1, the highest, will get a bottle of malt. And the malt is now more expensive than, and I'm serious about it. Don't worry. You see, maybe we'll get a time that you will get something more tangible, maybe $50, $100. But let's start with this first. So, and everybody will get it. Basically, you're going to get a bottle of Pepsi. If you get it accurately, or your answer is the perfect one, is the most appropriate, you're going to get a bottle of malt. I know that all of you are bigger than, some of you can even buy 10 crates of malt. I know that it's fine. But in life, we do some things actually to hold ourselves responsible to knowledge acquisition and to relevance in affairs. And that's the way I want you to see this. So next week, Thursday, I need everything to be submitted to the moderator. So by Friday, the moderator will send them to me. In fact, let's make it by Wednesday latest. So by Thursday, the moderator will send them to me. Then I will decide by Friday. So by Saturday, the arrangement must have been made for your Pepsi. And if you get it wrong, not even a bottle of water you will get. Not even such water. So what are for hubs for grab? What are for grabs are a bottle of Pepsi for everyone who gets it right, and a bottle of malt for the person who got it right the most. So, well, I think, so moderator, please, can we move to comment now? Is Mr. Emmanuel still in class? Is he in the room with us? Is he back?
Mr. Emmanuel, please, if you are in the call, you can just unmute yourself now.
He might be busy. We called him. I reached out to him earlier. Okay, so can we proceed to comments straight away?
Sir, did you get the 2 presentations from the 2 mentors when you joined the call?
Yes, I got them. I think I even started with the first presentation and the second one. The first presentation appeared very brief. Is that correct? I think about 3 slides.
Yes.
So, and okay. So do I proceed? Oh, somebody is asking what's the assignment? Is it based on the question you asked earlier? Yes, it's based. Now, the question, so limit yourself. Let this be your question. I have applied for transcript. So I made an application to my university to send my transcript to Harvard Law School. And in this, and my university processed, made some request for information from me and told me that the conditions of processing it. The father told me the timeline it will be received by Harvard Law School. I made the payment and they processed it, and Harvard Law School received the transcript. Aside right to data portability, which was clearly exercised, and right to be informed, which I was allowed to have enjoyed. What other rights? Okay, so would you say right to access was demonstrated in that situation? Yes or no? Have your answer to be in 1 paragraph or 2 paragraphs, but not more than 1 page, please. No more than 1 page. And of course, I told you what the prices are. Yes, please let it be typed. Somebody is asking, Chineye, I should flog you. Do you want to write it by hand? No, now, at this stage. So it must be typed. And I've told you what the prices are. You have Pepsi and you have malt. And for anyone who prefers Coke, don't worry, it can give you Coke as an alternative to Pepsi. So, yeah. So yes, somebody
okay,
said
that.
Okay, so we
can take the comments now.
We can waterize it. If you don't like soda, we can waterize it. Okay, so the comments. I think the what is it called? I think the presentation were not detailed enough, and this to me applies to the 2 groups. And let me say this, there's something that stands out for me. I've always been making this comment, and I think you guys really need to do much of it. learn to apply cases, decided authorities in your presentation. That's number one. But number two, and more importantly, let me ask you, and I'm going to do it by way of questions. Who made the presentation for group one? The presenter for group one, can I have you on the car? Can I have you?
The first that presented was group two, and I made the presentation. I said that group that presented was group two, and I was one that made the presentation.
Okay, that's Chika, right?
Yes, yes.
In your work, in your presentation, you did not make mention or make reference to NDPR. Is that correct?
No, I only made reference to the Nigerian Data Protection Act.
Yes, I said you did not refer to NDPR. Is that correct? That you did not refer to?
Yes, I did refer to NDPR.
Chika, what should I take? No, yes, no, yes. Did you refer to it or not?
I did refer to the NDPR. I only made reference
to NDP. So why? I said why?
I think majorly because we're still unclear on the position of the NDPR with the coming of the NDPA.
I didn't get that.
I said I think it's because the provisions of the NDPR are still being looked at with the coming of the NDPA. So personally, we are unsure.
You are unsure what?
Well, I thought it was best to use the latest legislation.
Okay. And so let me ask you, what if you have some provisions in NDPR that are more detailed than NDPA? Don't you think you're better off to cite NDPR? Or let me ask you again, do you think NDPA repeals NDPR?
No, I don't think it does. I just said that I thought the best is the latest legislation.
Okay, well, this is what I would say. I think it's very important. I think it's very important for you to, you'll have done yourself a whole lot of good to make reference to NDPR. Now, and I will tell you why. Now, the reason is simple, because NDPR is still applicable to data subject right, and it makes provision. In fact, it actually makes, I'm able to think that some provisions that seems actually a bit more detailed in NDPR on data subject rights. So for me, it is very, very important until it is expressly repealed. You do not have a reason to leave NDPR out. You do not have it. For example, I just filed a suit on Friday, and trust me, I only relied on NDPR in that suit. I just filed it just this Friday. The thing is that there are provisions in both NDPR and NDPA, but because as at the time of the alleged commission or omission, it was only NDPR that was enforced. However, what I did was that as much as I relied on NDPR, I now made reference to NDPA, because one of my reliefs is for the court to order the performance of that particular act, going forward by the respondent. And so what I now did is that I now even, aside the fact that I made reference to NDPA, portion of NDPA in my written address, and I said that the respondent shall be ordered to comply with that provision of NDPR and other extant legislation and regulations. In that situation, as long as the court actually granted that order, the respondent will be bound to ensure that the performance of the does not only comply with NDPR, but NDPA and other subsidiary legislation made thereunder. So my point is, please, when you are discussing any subject under data protection in Nigeria today, or under no circumstance should you leave out one, Section 37 of the Constitution, two, NDPR and its implementation framework, which was issued November 2020. Three, NDPA. Then four, any other regulation, guidelines, guide notes, or frameworks issued under NDPA. So it's very important. And of course, lastly, please ensure that you shop for cases. It's important. Cases make us understand principles of law better. Now, the truth is that quite a number of those rights you mentioned, there are some of them, almost all of us here, can relate. But, you're going to give us a very engaging conversation if you have picked up a particular case where something happened and the court looked at it from a very complex perspective, and the court was able to say, look, this doesn't apply, this is disagreed with, and this is the position of the law. So all of us will learn from it. So what I'm saying by that is that you can realize that when I gave you this scenario of you applying for your transcript, now almost everybody in the room agreed that one, right to data portability was exercised, right to be informed was exercised. It was only right to access, that we were divided on. So give us a case law from which we can profoundly learn. So for me, I think on that note, I'll just leave my comment at that. I could see some questions in the comment section or the chat room.
Yes, sir. Mr. Emmanuel is back on the call, so
he's back. Oh, great.
Okay. On the presentations.
Hello, good evening.
Yes, thank you very much. Good evening, sir. Mr. Emmanuel is having network issues, so I don't know if you can hear him. I can't hear him yet.
Okay, sorry, my network is really unstable.
Okay, we can hear you now.
All right, and okay. All right, good to be back again, and good evening, Mr. Solomon. Nice to have you today, and I was really enjoying your position until my network disconnected. So, Mr. Hussein, is it time for the questions?
Yes, yes, it's time for the questions.
Okay. Okay, so should I take the first one?
Yes, sir. Did you see the questions I sent on the chat box?
Yeah, is there a stipulated time in which a data subject is required to exercise his rights? Okay, when it comes to exercising of rights by data subjects, there is no stipulated time, there's no limitation of time. You can invoke your right, you can institute an action, you can ensure that your right is properly addressed at any given time. And sorry, let me check. The question says, exercise is right. So for that answer, I'll be categorical about it that at any given time, a data subject can exercise its rights and institute an action and request for everything we have listed when it comes to his right. So there's no limitation of time to exercise your right. Then, can I take the second question as well?
Yes, sir.
Okay. Okay. Data subject right. Bad. As I said earlier from the start, a data subject right is not bad. Like that right can be exercised at any time, So he can seek redress from the controller, from the processor, from even the authority. At any given time, he can seek redress and get his rights properly respected. Then I'll also add that based on what we have actually discussed when it comes to the right to access, right to be forgotten, which is right to erase, then right to restrict processing and data portability. Also, the last one, automated decision making. These are all rights available to a data subject. Now, in the EU, which I understand how they operate properly, a data subject has within a month, like to get redress from a controller or a processor in which he has applied to address any given question, where the controller cannot meet up with that particular 1 month, he is supposed to give a written explanation to the data subject to inform him that he will need an extension of time in order to attend to that data breach or any redress that the data subject needs at that given time. So that is how it is operated in the EU. But when it comes to the position of the Data Protection Act, I guess Mr. Solomon will be able to explain better with that regards. Thank you very much.
Thank you very much.
For the third question, I should go on with the third question as well.
Let's give the third question to Mr. Solomon, while he also contributes to any of the questions he wishes to put on. I think we have a third question now. So, Mr. Solomon, so I will call on you to also talk on the fourth question.
Yes. Sorry, I have to stand up from my computer. So, what questions do you want me to? Oh, which one?
Question number 3. What are the remedies available for organizations where the breach of a data subject right is not due to their negligence or breach from their end, but the fault of another? Maybe.
Okay, so now under principles of data protection, there's a particular principle that ordinarily should take care of a breach being from another, from a third party. Does somebody in the room remember that principle? Okay, so I'm saying when we're taking principles of data protection, I mentioned a particular principle that the data controller has a responsibility to ensure as one of the principles. And I'm saying if he had actually put that in place, then there will not be a story as to issue of a breach by a third party. Okay, so for anybody if we do not remember, does anybody remember that I mentioned of something called PET? Privacy enhancing technologies. Can we remember that?
Yes, sir.
Okay, so Miriam, so we mentioned privacy enhancing technology. What does that thing mean, actually?
So you said that that a data controller must at all times ensure that there are facilities that will enable the data controller comply with privacy requirements. I think that was what you said that there's.
Well, it's, I mean, you are almost, maybe I will give you 60%. But I'm sure if I push you for that, you actually hit the point. So a data controller has a responsibility to ensure that there are sufficient privacy enhancing technologies in place to keep the personal data of data subjects safe and secure. Now, so Miriam, on that note, do you agree that is the position?
Yes, sir.
So, Ezine is actually working with, she's the data protection officer for Standard Chartered Bank. Are you with me?
Yes, sir.
So, personal data of some persons, including Lillian, got leaked. And Ezine comes up to say, look, we recognize you as a data subject, and we have done all we could, but I mean, the breach was due to a third-party hack. So in that case, we are not going to be responsible. And Miriam, you have been recommended as one of the finest data protection lawyers in town to who now? To Lillian, right? Yes, to Lillian. So Miriam, what would be your position? Will you say Standard Chartered Bank, for whom or for which Ezine is data protection officer can just go home, that you see, they didn't do anything. It wasn't their fault. It was the fault of some hackers, maybe anonymous. So Lillian, let's just commit it to the hands of God. You know, life happens, and it lasts. You know, things happen anywhere in the world, though, honestly. Is that your position, Miriam?
No, sir. I think the bank will be held liable for the breach.
But they are not the cops now. It wasn't their fault.
If they had put in the privacy enhancing technology, if the privacy enhancing technology was in place, probably the breach would not have occurred. That's what I think.
Is that what you think? As a lawyer, you think so?
That is what it is, right?
Lillian, your client has even run away. I don't
know. No, I'm here.
Lillian, your lawyer said she thinks. Do you want to proceed with her thinking? Or
So I don't think, I'm sure.
Yeah, sure. Okay. So, Miriam, Lillian.
Sir?
So you got a badass lawyer, a very fine data protection lawyer. She's
Yes,
saying she's
so they must recover my loss.
she said she's sure that if they are put in place sufficient privacy enhanced technologies, that breach would not have occurred. So if that breach occurred, it means they did not put in place sufficient privacy enhancing technology. So Chika has also run away. I don't know. Chinaya, are you still in class?
So which of the Chika?
Yes, I'm here. I'm here.
Any one of them. Okay, so yes. My Chika. Anyway, the two Chikas are my Chika. So now, Chinaya respond. Chinaya, are you still in class?
Yes, I'm here.
So Standard Chartered Bank is considering briefing you.
So which?
So Chika, don't worry. I want to come back to you. So Chinaya.
I'm here. I can hear you.
Standard Chartered Bank is considering briefing you to represent them in that matter. Are you taking up their brief? And if you are, yes, why? What will be your position? If you are not, why don't you want to take it up? Or if you want to give them advice, what do you want to say?
Well, in giving them advice from the scenario you painted, by entering a contract with Lillian to have access to her personal data, they have a duty, by virtue of that contract, they have a duty towards her to ensure that the information they hold of her is duly protected. And seeing as they're giving the excuse that it was hackers, which means they didn't even exercise the amount of diligence I was expected of them. So I would advise them to either opt for out of court settlement, because if the reason is quite flimsy that it was hackers that had access to the information, thereby it's not their fault. No, it is generally their fault because they were in possession of the information that they didn't protect it enough that hackers had access to it. So in advising them, I would tell them to probably settle with Lillian and ensure that if Lillian would continue to bank with them, that they should ensure that the proper enhancement technologies are put in place so that there won't be a repeat. So that's
great. Excellent. Okay, Chika Uzuji. Chika is no longer in the class. My other Chika, where are you? She's not in the class too. Okay. Aha.
Hello, sir.
Hello? Okay, yeah. See, I know you like money. Can you hear me, Chika?
Yes, sir.
I said, I know that you like money. Or do you disagree with that? Sorry?
Everybody likes money.
Oh, come on.
Everybody likes money.
You like money. So, do you disagree with? Do you agree with? Is that? Who just spoke now?
Chineye.
Chineye, yes. Do you disagree with Chineye, or do you agree with that?
No, I agree with that. I think the best thing for them would be an out of court settlement or a negotiation, mediation.
You don't have to go to
An
court.
alternative to litigation.
You don't have to go to.
No, it's not for the best. It's not for the best interest of the client to go to court, because those alternative dispute resolution provide privacy to the breach that the company allowed happen. So it's not the best interest of the company.
Mr. Emmanuel. Mr. Emmanuel. Is he still in the room?
Sorry, Mr. Solomon, I missed it. Can you come again? Sorry.
Yes. No. It's not. I've not even said anything.
Okay.
Your mentees, some of them got a brief, and their reflection seems to me that they have spoken to you as the consultant, and that's why Lillian was banking with Standard Chartered Bank, though hypothetical case. So some personal data got leaked. There was a breach, and Standard Chartered Bank was saying, look, they had Lillian as who is actually their data protection officer? Is it not Lillian? Guys, answer me now. Is it not Lillian?
It's Miriam. It's Miriam. Miriam.
Miriam is the lawyer to.
It's Chineye, it's not Miriam.
Miriam is the lawyer to Lillian. Why Chineye is the lawyer to Standard Chartered?
So who is actually DP of Standard Chartered? Okay, so Mr. Amanda, are you still on the call? Okay, you're still with us, right?
Yes.
Okay, so now we now looked at it. The DPO came up and said, look, you see, it's actually not, it wasn't our fault. What happened was that some hackers, some terrible hackers hacked into our database, and of course, we had a breach and all of that, and that was it. We are sorry. We are duly sorry. So Lillian is saying, look, I'm not going to take sorry. And Lillian, briefed Miriam, and Miriam is saying, look, I don't care what their story is. They need to pay for this because they have a responsibility as a data controller to you to put in place sufficient privacy enhancing technology. So at the end of the day, Standard Chartered Bank briefed another counsel in the room in person of Chineye. And Chineye said, look, you guys have a responsibility to her. Our data has been breached, whether internal breach or one location by hackers, it doesn't matter. You have the responsibility, duty to her. So in that situation, I said, okay, so what do you advise what would Chineye advise as a counsel briefed by Standard Chartered Bank? She said, well, she would advise that they actually settle out of court with Lillian. And of course, she would recommend that going forward, they put in place sufficient privacy enhancing technology. So in my head, I was thinking, are these people have they spoken to Mr. Emmanuel? Have you consulted for them? I mean, for Chineye precisely. Why didn't they consider option of litigation? So that at the end of the day, some of us litigation lawyers will have enough money to chop. Mr. Emmanuel.
Yes, Mr. Solomon, thank you very much for bringing it here. And let me first of all drive back to our part of our discussion last week. Last week, okay, we made mention of certain aspect of impact assessment. But before impact assessment, I believe that you getting a very sound training for the mentees, getting this sound training in data protection, you're supposed to understand that there are certain roles that you are to play, and those roles involves risk management. So when there is an incident, whether it is due to the negligence of the company or not, or whether it is not out of their negligence, but as long as there is a breach, one of the first action to take is a very prompt investigation. And that investigation is actually to examine the situation, to know the extent of the incident. And knowing the extent will vary whether to inform the data subject or whether to push for the relevant authorities to come into the matter. So when you have scenarios like this on the table, that is what gives birth to data protection impact assessment. Last week, we made mention of it. So I believe with this now, you have a better understanding about it. Last week, we made mention of categorizing the risks into high risks, medium risks, and low risks. So with this bridge on ground, you'll be able to look at it and know if this bridge can be categorized under high risks, medium risks, or low risks. Then when you have such kind of evaluation done, the next thing, as I said, there are instances where it is very, very important to inform the data subject of such breach. And it is also important that as a DPO, you must collaborate with the relevant authorities to ensure that that risk is either mitigated or put under control. And where there is need for compensation, then the data subject should be well compensated or anything, but there should be what they call a proper data breach response plan. That is what they call the data breach response plan. You must have a plan in which you are to attack any form of breach, whether internal, external, your negligence or not. In fact, as a matter of fact, as a controller, if a breach should occur from a third party that you have contracted, whether it is your fault or not, it still falls under contractual obligation. The breach will still fall on you. The breach will certainly link back to you. So at every given time, a controller has that responsibility to have a data breach response plan, so that he will be able to have a comprehensive data breach approach and control and make sure that everything is put in place, whether that such breach is out of his negligence or not. Mr. Solomon, I don't know if I have given a little.
Your response was quite robust, and to cap it all, like I said, I think you would not have agreed them to. You would not have advised that their counsel should lead them on to litigation. I'm talking about the Standard Chartered Bank now.
Yes, actually, one of the first, they can't just start thinking of litigation from the start, even though you're a lawyer. Now, in this very field, the first approach is not actually litigation. There are certain things that is required of you to be able to put in place to control the risks, to mitigate it. So that is the essence of the impact assessment. That last week, we didn't touch much on it, but just know that data protection impact assessment is actually a very, very fundamental aspect of data protection. And as a DPO, you are to have a very good knowledge about it, understanding risks, understanding how to categorize them, understanding how to properly manage them, and ensure that both the data subject and both the authorities are all carried along, and everywhere is properly and everything is properly managed.
Okay. So, Mr. Emmanuel, on a final note, so your position in this situation will be that while Miriam, who is the counsel to Lillian, the data subject will be offensive in a position, and most likely in the first correspondence, threaten litigation, then Chineye ordinarily should not assume, and of course, she has taken a position which is not to even think of litigation at all. So I am thinking one of the best decisions she has taken, not to think of let's go to court against them, is the fact that considering litigation at that point will rather expose our clients as a data controller more, and to be such a data controller who doesn't value protection of personal data of our teaming customers. Will you agree with me on that?
Sorry, I got lost at some point. Please, can you just rephrase for me?
So I'm saying Miriam is a counsel to Lillian, whose personal data got.
Yes.
And Lillian in the first correspondence actually threatened litigation. Now, Chineye is saying, as giving us a position that, look, as the counsel to the bank, I will not even think of litigation first. You and I know that there are some lawyers that if they are defending, they will think, okay, let's see how to explore litigation. Now, she is saying, look, we will not think of litigation. We'll think of how to talk to the data subjects, how we can remedy what has been done, and how we can put in place, robust data response measure. But beyond that, let us set out of court. So I'm saying, you say that position to set out of court was very good to particularly manage the reputation, the corporate reputation of the data controller.
Yes, excellent idea. In fact, that is even part of that's what is expected as a lawyer. I believe that, especially in this area, in this field, it requires more of you able to mitigate the whole risks. And part of mitigating the risks is by talking to parties and ensuring that both sides are all under control and proper management. Proper management is actually the key. So with the position of looking out for alternate dispute resolution, maybe mediation or arbitration on the whole thing, and looking for how they can put proper, it's actually a wonderful idea. And I believe that we thought
of
Mr.
the
Solomon?
data.
I didn't get you, Mr. Solomon.
I said with the particular intention to protect the image of the data controller.
Yeah, in fact, most organizations, so a very key, in fact, they don't joke with their reputation, except in Nigeria. Most organizations, they don't know the value of reputation. But one very thing organizations don't joke with is their reputation. So they would want their matter to be taken to court and their name, their reputation. In fact, goodwill is actually an asset.
Yeah, it is. It is.
So, but in Nigeria, you will see a bank that someone is dragging on Twitter, telling the bank that you guys deducted this money from my account, and the bank would be so nonchalant about the whole thing, and they don't mind their identity being exposed to the world. But every organization is concerned. In fact, they're very concerned about their reputation. So any lawyer that is saving their reputation is an asset to them. You are actually displaying that risk management, and trust me, I agree so much, an excellent approach. Get every party settled and manage everything perfectly.
Thank you, sir. Chineye?
Yes, I'm here.
So when you get paid by your clients, remember me.
Okay, I will.
It's all right. So can we take the next question there, or they all be attended to? Are all the questions taken?
Sorry, I've been muted. I've been talking. I said it's remaining the last question.
Okay, which is?
Please, which court has the jurisdiction to hear and determine matter on breach of data subject rights? Which court?
Which court? You know, I raised that issue last week. Data Protection Act says any court of competent jurisdiction. So which court is that? Miriam. Miriam.
Is Miriam still on the call?
I am. Good evening, sir.
Yes. So which court are you going to? Or Lillian?
I have no idea. That's why I asked the question, sir.
No idea. No. Okay. Is it Miriam or Miriam? Which was the consent to Lillian?
Is Miriam.
Is it Miriam or Miriam? Which one?
Is Miriam.
Miriam, are you the consent to Lillian or Miriam?
Sir, I am not. My own name is Miriam.
Oh, we have Miriam now. Where's Miriam?
I'm Miriam, M-A-R-I-A-M.
Well, there's a Miriam. Is there no Miriam?
Yes, sir. Yes, I'm Miriam, sir.
Are you not the consent to Lillian?
Yes, I am, sir.
I said, which court are you going to?
Okay, I think the High Court.
Which of the High Court? State High Court or the Federal?
State High Court, as the State High Court has jurisdiction over fundamental human rights. So
Okay, so which other court can we go to?
Federal High Court.
Federal High Court.
What about magistrate courts?
No.
Who said no?
Are you come?
Who said no? Can we go to magistrate courts? Okay. Oyinkansola, can we go to magistrate courts? Oyinkansola, can we go to magistrate courts? Can we go to area courts? Can we go to customary courts? Lillian.
Sir.
Can we go to magistrate courts?
No, sir.
Customary courts?
No, sir, we cannot.
Area courts?
No, sir.
But the law says any court of competent jurisdiction.
Okay, I think by that they mean competent jurisdiction as listed in the Constitution, that's Superior Court of Record. And if these other courts are not listed there, then we cannot take the matter on data privacy issues.
So I don't understand. So for a court to be a court of competent jurisdiction, what does it mean? What does the law say about it?
If the jurisdiction of that court has been listed in the Constitution of the Federal
Okay.
Republic.
So data protection matters. Is that listed in the Constitution?
Data protection matters should fall under fundamental human rights issues.
Okay, should fall under it.
Yes, I think so.
So, but when we have a provision that says any court of competent jurisdiction, what do you think we should do with it? Should we just assume that it is referring to High Court and Federal High Court?
Yes, I think so. Because maybe not refined. Maybe not refined to High Court and Federal High Court alone. I think National Industrial Court too can come in certain instances when it has to do with the right of an employee that has been reduced and all that. But then, because the State High Court has unlimited jurisdiction to entertain matters and fundamental human rights issues can also go to State High Court, I think that's why we can assume that matters on data privacy issues can go to the State High Court as the court of first instance, because we cannot take matters like this to the Court of Appeal or the Supreme Court as court of first instance. That's my own.
You're not getting my point. My question here. Okay, so let's look at it. Freedom of information provides for courts under the law to be High Court or Federal High Court. If I say High Court and Federal High Court. The Cybercrime Act provides for Federal High Court. What courts does the NDPA provide for? What courts? I'm listening. Okay, so let's, in attempting to answer that question, the very best anybody can do is to say, look, I would rather go to a Federal High Court, or I would rather go to a High Court of the state. Now, the law using a phrase like any court of competent jurisdiction is grossly misleading and inadequate. Now, for benefit of doubt, the phrase any court of competent jurisdiction does not mean anything. Because before a court can be a court of competent jurisdiction, three things have to be in place by our court. One, that court has to be duly constituted by the formation of the court. Whether it is a one-man bench court or a three-man bench court, or a 5-man bench court. Number two, that court has to be clothed with subject matter jurisdiction. And number three, there must be nothing preventing the court from exercising jurisdiction. For example, issue of local standard. So now let me ask you, what do you think confers jurisdiction on a court? Any attempt?
Is it the Constitution?
I know about what confers jurisdiction on a court is either what confers jurisdiction on a court. It's either a particular statute or the Constitution.
Yes, you're right. You're very correct. Jurisdiction of a court, subject matter jurisdiction cannot be assumed, cannot be implied, has to be expressed. And let me now clarify this to you for avoidance of doubt. Now, for you to be able to successfully litigate data protection under the guise of let me go to federal high court or let me go to high court of the state because it's a matter of privacy, you need to bring it under section 37. Now, I can tell you categorically, data protection matters is what should be brought to a court without having to come under section 37. But the only way you can successfully bring it before a federal high court or a high court of the state or high court of FCT is to, first of all, you bring it as a fundamental human right violation. And of course, you're on the face of your motion or summons, it will reflect clearly that in the matter of enforcement of section 37 of the Constitution, then you bring in NDPA. And your argument will be so strong to show that that particular provision or the entire provisions of NDPA are extension of section 37 of the Constitution. That is how you can safely do that. But we are saying here that, look, NDPA is a separate provision instrument on its own, statute. So we should make provision on its own for laws, for courts that have appropriate jurisdiction. When you look at the Freedom of Information Act, how many of you are aware that freedom of information is an extension or is an offshoot of section 37, section 39? How many of you are aware? Okay, now let me clarify this. Section 39 says you have the right to express yourself. And this right includes right to hold opinions, right to access information and ideas, and right to disseminate information and ideas. Is right to information in that section 39 that way?
Yes, yes, it is.
Yes, it is.
So what the legislators did is that they now took right to information, from which is right to access information and ideas. They took it from section 39. They now made it a separate statute. They made a separate legal framework for it as a statute. And in that statute, they now made a provision for a court, which is specific, and that is High Court and Federal High Court. So, because you see, when you do not do that, let me tell you, as we speak, some cases have been filed at the magistrate court as of today on Data Protection Act. Do you blame them? No. Because the law says any court of competent jurisdiction. Now, as students of law or as practitioners of law, no good law should leave the people or the practitioners or the enforcers in doubt as to what its meaning is. And no stakeholder should guess. The decision of a court is not what you must guess about, what you should guess about. It should be what is specific, what is clear, what gives a party sufficient information ahead of even a violation. So what we are saying here is that that provision of the law is faulty. A provision that says any court of competent jurisdiction without first specifying such court with subject matter jurisdiction on that in that law is faulty, is invalid. You must specify court with subject matter jurisdiction. So, and that's what has informed the case Solomon Okedara and Nathan Jera of the Federation. That case was filed on Friday at the Federal High Court in Abuja. I have asked that in this law, there is no specific provision for a court with subject matter jurisdiction. Even if the formation of the court is in order, even if the party has local standby, does that court have subject matter jurisdiction in that case? Does it? So we cannot all the time say, yes, don't worry, you will bring an action under Section 37. So if we will need to bring an action under Section 37, then why do we have to enact a specific legislation for that purpose? Why did we have to enact Freedom of Information Act? Why can't we just all be going under Section 39 for access to public information? Do you guys understand what it's all about?
Yes, sir. Yes, sir. We understand.
So, as of today, as student of law and as practitioner of law, if you need to approach the court for violation of any provision of NDPA, please go to Federal High Court, High Court of State, or High Court of FCC. But please, don't just do that without coming under Section 37. If you do that without coming under Section 37, if I'm acting for the opposite party, I will say, look, the court doesn't have jurisdiction. Because even the law itself does not specify jurisdiction. So a court of competent jurisdiction is any court. And if I go to, what is it called? A magistrate court. If you tell me that, look, I cannot come here, and I will tell you what the law says is a court of any court of, in fact, I love how that law puts it, that provision put it is so ridiculous. Any court of competent jurisdiction. What does that even mean? In my address, I said that thing is nothing but mere fanciful nonsense. It doesn't mean anything. You must have specified earlier in that instrument, in that statute, what court? That's what that section 65 says. It says a court means any court of competent jurisdiction. For such a specific legislation, you cannot just tell us any court of competent jurisdiction. Like I said, which means nothing. You have to specify. Because what you would do is that any party who does not go under section, all parties will now have to come under Section 37 for enforcement of data protection right. All the time you have to, because if you do not come under Section 37, then you now have to tell me where you have derived where that court has derived is subject matter jurisdiction. That's the implication. We have to come under Section 37 at all times. And when you have to go under Freedom of Information Act today, all you need to do is to approach the High Court or Federal High Court without having to come under Section 39. So I think that is clear. As to what the law says, the law is not clear about the court that has jurisdiction. But if you need to challenge any violation, go to Federal High Court, High Court of FCT, or High Court of State, but please do that coming under Section 37 of the Constitution. I think we have actually exited that time. I think in whatever manner, 1 or 2 learnings have been made today. So thank you guys for a beautiful time and a beautiful evening, I will say.
Thank you, sir.
Thank you, sir.
Thank you very much. Thank you very much, Mr. Solomon. Thank you very much, Mr. Emmanuel, for being on the call with us to the end, and Mr. Solomon also for answering our questions and also the comments on the presentation. Thank you, everyone that stayed with us. We are like a bit late from the time that we were supposed to end the call, but I believe our mentor have really been saying really very, very impactful, answering the question and also explaining the topic for today. Thank you very much once again, everyone. We can for the assignment that Mr. Solomon gave us, we can all go back to YouTube and just maybe you forward the recap you are watching on YouTube to that point where he was asking the question, where he was repeating the question, so that you can get the question that he asked and how he wants the answers to. The deadline for submission is Wednesday, so I will be making the announcement on Wednesday when you are submitting your PowerPoint presentations soon. So thank you very much, everyone, for staying with us, and have a good night. Bye-bye.